Okay, let's go on the record. This is a matter of Pratt versus Employers Mutual. Counsel, state your appearances, please.
Good afternoon, Your Honor. Paul Mellenbach on behalf of the plaintiff, Pratt.
Good afternoon, Your Honor. John Schutza from Mary Farnan and Ryan, appearing on behalf of Employers Mutual Casualty.
Okay, and as I understand it, we have two matters before me today. It's the hearing on the rehearing of the initial motion for summary disposition and a motion to bifurcate the trial. Are those the only two matters in front of me today, gentlemen?
Your Honor, I only have one. I've got defense motion for rehearing, and I think I agreed with Mr. Ryan some time ago that we would have the hearing on the motion to bifurcate trial closer to the trial date, which hasn't been scheduled yet.
I only had the motion for rehearing on my schedule.
Fair enough. Well, that's why I ask. Okay, so I ordered a hearing on this motion, which typically, unless the court requests a response or schedules a hearing, I just simply rule on the motion. The reason I did that is I got a whole bunch more photographs than what were presented the first time around. And I wanted to give the plaintiff a chance to weigh in on those and then hear additional arguments. So let me, I denied the motion because there was some testimony that the decedent actually ended up on the hood of this pickup truck. And my sense that if he was standing on the ground at the time of impact, it's highly improbable that he would have ended up on the hood of the pickup truck. But I didn't have the photos that we've got now. So the photos that we have now, and thank you for electronic version. I don't know what happened to the color photos I saw when I first reviewed the motion for rehearing. We've not been able to track them down. We've got photocopies of them, but so having them in electronic format is very helpful to me. I have that open, so give me just a moment. And I'm going to share my screen if I can figure out how. I think I've done this once before. Well, I see the email that the exhibit's photos were attached to. Let me just click on that and see what happens. I don't know why I'm having trouble pulling up the photos. Oh, here we go. All right, let's try that. Hold on a minute. Let me try again. There we go. I had to have that window open. Okay, so I'm going to give you both a chance to make arguments, but I have some questions that I wanted to have answered. I saw references in your supplemental filing that the decedent was found lying on the A-frame of the passenger side tire. A-frame is part of the front end suspension. I do know enough about cars to know that. And it's nowhere, I mean, it's well under where the hood would be. So do you see where my cursor is, gentlemen?
Yes,
Yeah, Judge, but my understanding is the A-frame is up towards the distance between the hood of the car and the top of the car vertical along the windshield.
That's not my understanding of an A-frame. An A-frame is part of the front suspension. Each wheel on each side has an A-frame structure, and it's really close to the wheel. It's nowhere close to the hood. It would, I mean, did you have these photographs when you were deposing the emergency technicians to ask them, okay, where was his body when you arrived at the scene?
We had some of them, not all of them. The photographs that were supplied at the time we took the deposition were ones that were supplied by the Columbia Township Police Department. These photographs were obtained later from the Michigan State Police. Columbia Township didn't have the same ones. The testimony from the first responders is that he was lying on the hood. Wasn't that he was lying on the wheel. I think that's fairly established and consistent with what all of the first responders testified about. And they found him. There weren't any photographs of him lying on the vehicle at all. None were taken of the body.
I understand that. I can tell by where the pool of blood is that he was definitely in this area. Where exactly vertically in the picture, I can't tell. But there's a whole lot of blood on the ground right next to this. When I go to the photograph, hold on, let me find it now. This one. So this is the ledge that the garbage men can stand on and often do as it's rolling down the road. I think we've all seen them holding on to the side as they're stopping at the different driveways. The hood of the truck is here. The A-frame would be way down in this area here.
just for point of reference, in case somebody is looking at the transcript of this hearing, the photograph the court's referring to is number 33 of 65, I think. It is indicated at the top of the screen.
So, and I'm just guessing from looking at the pictures and what I've heard described of the accident, that his injuries were more to his lower torso and legs than to his upper torso. Is that borne out by the medical records?
It was more lower middle than it necessarily was. Nothing up in the shoulder area. No, it was more along the middle and upper thigh, pelvis area.
So whatever pictures we had the last time around caused me to, well, if he ended up with his upper body on the hood, it just struck me as highly unlikely that the impact would have put him up there. Something had to get him up off the ground for him to be up there. But now when I'm hearing testimony that he was on the A-frame, it's far less plausible to me that he would have ended up here where I'm pointing to the hood area.
Again, Your Honor, I think the distinction is the difference between an A-frame and A-post. It's my understanding that according to Sergeant Niles, when they arrived, his feet were suspended above the ground. His body was pushed up and over the pickup truck so that his lower half was sitting above the front passenger wheel, which you've acknowledged, while the top half of his body was against the A-post of the passenger side of the white pickup truck.
I think it's helpful if we look at what the Michigan State Police said, and In their report, which is part of Exhibit A of the Columbia Township Police Records at page 12, they say that the garbage worker was pinned between the front of the F-150 and the back of the garbage truck. The garbage worker was found wedged in a seated position on top of the right front tire area of the F-150. And Sergeant Niles also says that he, meaning the decedent, was in the passenger side of the bumper. He was more incorporated into the bumper, the quarter panel, the headlight area. So that's the area that the court's pointing to right now.
So backing up, let me go back to that picture I had earlier, which for the record is number 36. Well, there's a number at the bottom or the number at the top? Which?
Well, if you look at the very top, Judge, it's got 37/65 right now.
Oh, that's covered. That's covered up by a dialogue that I see. I see it now. I had a open dialogue that was covering that up. So this is 37 of Exhibit R. So he was, according to what you just read, he was in a sitting position with his back to the pickup truck and his front towards the garbage truck. And where he was sitting was the area that I'm showing with the cursor right now. Do I understand that? That correctly, Mr. Schutze?
That's my understanding, yes, Your Honor. That's consistent with what I just read, those excerpts.
All right, Mr. Millenbach?
I think if Mr. Schutze would read it again, I don't have it in front of me, I can take it out, but if you can read that excerpt that he just read from the police report, I don't think it necessarily indicates it was sitting on the tire. I believe he said it was sitting with his feet dangling, his feet up off the ground.
Read that section again, Mr. Schutze, if you have it available.
This is directly coming from page 4 of our reply to the plaintiff's response for our motion for rehearing. And the first full paragraph, we say, per the Michigan State Police incident report, quote, a garbage truck worker was pinned between the front of the F-150 and the back of the garbage truck. The garbage worker was found wedged in a seated position on top of the right front tire area of the F-150. And then the other thing I read was from Sergeant Niles of the Columbia Township Police Department, his testimony that he was in the passenger side of the bumper. He was more incorporated into the bumper, quarter panel, headlight area.
So this crumpled piece here is the front right quarter panel. And I see, because of the indentation here, where I envision they found him from the description that you just read. Which, at least in my mind, makes it far, far less plausible that he was either on or jumping onto the garbage truck at the point of impact. One thing seems crystal clear to me: the one place where he wasn't was on this ledge. Because if he were on this ledge, there's no way he could have been pinned between the back of the garbage truck and the pickup truck in the area where the state police report indicates he was found. But it would have been a whole lot better if the state policemen were questioned with reference to the photographs. It just puts me in a position as to try to reconstruct in my own mind from a police report as opposed to from live testimony. The police report's not even going to be admissible, unless you stipulate to it. It's hearsay. The state policeman who made the report and whoever else was at the scene is going to have to describe what he saw when he got there. And fortunately, we do have some really good pictures that could be used to explain that.
May I just
go ahead.
Interject? While the police report itself, conceding for purposes of argument that the report itself may not be admissible, on summary disposition, the cases tell us that it's the content that needs to be admissible. In other words, the opinions use the word whether or not the content is substantively admissible. So you can put a report in that contains statements that somebody could testify to. It doesn't have to be on summary disposition that the report itself would have to be admissible.
No, I understand the point you're making, that we can assume that the officer would testify consistent with his report. It is documentary summary of what his testimony would be expected to be. I take it that officer was not deposed?
No.
Who all was deposed?
The officers from the Columbia Township Police Department, Sergeant Niles directly, and then another gentleman, Jeffrey Simpson.
And then the passerby motorist, I'm looking for his name here. I might find it in a minute. Wayne Gootee, Gootee. He was also deposed. He's the fellow that testified that he saw Pratt standing at the back of the garbage truck with his back to the garbage truck moments before the collision. He said he was within 1 foot of the back of the driver's side of the garbage truck.
He didn't see the accident happen, though. He was going the other direction.
I understand no one saw the point of impact. We've got the other garbage man who knew he was generally in that back area at the rear of the truck on the ground the last time he saw him. The passerby says moments before the impact, he saw him standing on the ground in the back. But neither of those reports could exclude the possibility that he saw the truck and at the last minute jumped to try to get out of its way, tried to jump onto the garbage truck. When you've got limited options and a sudden emergency like that, it would be pretty reasonable for a jury to conclude that he would have tried to get away from it. And the best way to do that would probably be to protect himself with the truck itself. But I don't see any possibility that he jumped onto this platform. There's no way he could have been found pinned between the rear of the truck and the front of the pickup truck if he had been on this area. But he could have tried to jump into the back of the garbage truck. I mean, that's a far better fate than getting hit by a pickup truck.
Except there's no evidence that he did that, Your Honor. That's as equal a possibility as any other. And
there's no evidence that he didn't, Your Honor. I mean, we're obviously, the stop. I don't necessarily agree with the court that he might not have been on the step, but certainly that's a possibility. And the question of whether or not he jumped into the pickup truck is a possibility. And those are things that should be determined by the trier of fact. However slight evidence there might be, there's still certainly circumstantial evidence of the nature of his injuries, and the fact that nobody saw him would warrant this case to go to a jury to be decided by a jury.
Except that's not what the Supreme Court tells us. The judge knows this case. He's probably heard it cited 100 times, 200 times. Skinner versus Square D. Supreme Court told us years ago that if the explanation as to the cause of an event is equally as plausible as another cause, that doesn't get you by summary disposition. That's if they're evenly balanced, it doesn't get you by summary disposition.
It has to be more probable than not.
Exactly.
For the jury to decide, absolutely, and that's exactly where this case should go to a jury on that. Circumstantial evidence establish a question of fact. I think there's strong enough circumstantial evidence in this case to support a denial of the motion and a rehearing. There's testimony that he was on the hood. There's testimony that he's on the tire. There's testimony that from the closest witness to him that he said that he could have jumped up on the step. Tyler Street.
There's just no evidence. As far as him being on the hood, the court has seen the same pictures we have. That hood is so bent up by this collision, it's almost an inverted V, which means him sitting up on the hood. No, there's no evidence of that. There's no blood. There's no blood on the vehicle on the hood.
What were they going to call it other than a hood? It's a hood. It's an inverted V. They said it was on the hood, which is a V, and it's not a small pickup truck. I think it's larger than an F-150. It looks like an F-250.
Who testified that he was on the hood?
Sergeant Niles.
Which he later clarified in his deposition that he didn't mean he was on the hood. He testified, I'll find it again. He testified that he was in the passenger side of the bumper. He was more incorporated into the bumper, the quarter panel, the headlight area.
Never said he was more incorporated into that.
That's not on the hood.
His feet were suspended above the ground, pushed up and over. And this is Jeffrey Simpson's testimony, pushed up and over the pickup truck so that his lower half was sitting above the front passenger wheel while the top half of his body was against the A post of the passenger side of the white pickup truck.
No one has Mr. Pratt, and I should say this is a horrible accident. I don't think anybody's going to deny that. And everybody's got all the sympathy in the world for this family. But we're talking about the language of an insurance policy and what it means to occupy this garbage truck. There's no testimony that he was even touching the garbage truck at the time of this collision. That's key. And the fact that he might have been knocked into it, I don't want to argue the law because the court knows it. We've done that back in March. The fact that the force of the collision might have knocked him into the garbage truck, the cases have told us that's not sufficient to constitute occupying. He's got to be occupying at the time of the collision. So there's no evidence of that.
There's enough, I mean, in that photo alone, enough of space between that step and the hood of the pickup truck for him to be lying on the hood of it. It wasn't crumpled. There wasn't a V-shaped hood before it struck him. Was he lying across the top of the windshield along the front of the hood? No. Was he lying on the corner? Absolutely.
All right. Thank you, gentlemen. Although I am far less of the belief that there's room for the jury to conclude that it's more probable than not that he was on the garbage truck or attempting to get on the garbage truck at the time of impact. I'm afraid this record's just not well enough developed for me to jump into what would be the province of the jury. I will tell you, if that testimony gets established at trial, I may very well take the matter from the jury. But for now, I'm just concerned that the record's just not well enough to develop for me to reverse my decision on the dispositive motion. So I'm going to deny the motion for rehearing.
Thank you. I'll submit a proposed order.
Thank you, Your Honor.
Thank you, gentlemen. Have a good day.
Have a good day.
Oh, one other thing. Judge, in terms of, I don't think we have anything scheduled in terms of a trial, or that's going to be coming out in the pre-trial or anything like that right now.
Hold on a minute. Let me pull up your case. There should be something on the docket. Let me.
Pre-trial, but I don't.
Take me a moment to open up my case management system. It opens slowly and it takes a while to log in.
Well, I can follow up with your office if that's.
Well, I want to make sure I can take care of it right now. I just want to.
I guess in fairness to the court and to brother counsel, I'll indicate that it's going to be my recommendation of the client that they pursue interlocutory appellate review. And in that vein, for what it's worth, I'll be filing a motion to stay proceedings pending appeals, assuming that they approve it. I don't know whether they will or not, but.
And yes, you're right. There's nothing on the calendar. What I'll do is have my secretary find a date for there isn't anything keeping us from simply scheduling it for trial, assuming I can conduct a jury trial at some point. So a final pretrial and a trial date is what you'd like?
Yes.
All right, I'll send, John, if you could send a note to Nadine, tell her to set a final pretrial and a jury trial date sometime after Labor Day. I'm hoping that sometime around that time we'll be able to do jury trials again. All right, thank you, gentlemen. Have a good day.
Thank you, Your Honor.
Have a good day.
All right, looks like we've got an audio connection with everyone. Let me first, this is a matter of Bentley and Bentley versus Bentley. Counsel, state your appearances, please.
Your Honor, this is Stephen Rick. I'm here on behalf of plaintiffs Gail Bentley and Lynn Bentley.
Robert Kendall, appearing on behalf of the defendant.
All right, and it appears that all of the parties are also present. And this is plaintiff's motion for summary disposition. So go ahead, Mr. Rick.
Thank you, Your Honor. First thing I'd like to do, just as a procedural matter, is note an objection to Mr. Kendall's most recent filing, which he's labeled amended and supplemental brief in support of defendant's answer to the motion. The court rules specifically say that there's no additional or supplemental briefs allowed to be filed without leave of the court, other than the motion, response, and reply. So there's been no leave of court. I think that document is not properly before the court, nor should the court consider it or the affidavit attached to it. I won't belabor the court with reviewing all the details of the motion. I'm sure you've read it. You're familiar with the facts. I'll say that I've heard that when federal officers are trained to recognize counterfeit money, what they're trained to do is look at the real thing. And so that analogy applies in this case. I think the judge needs to look at the real thing. What have the parties actually said here? Not what is the speculation or assumption or what might have been said. What do the text messages say that the parties actually exchanged? If you look at those words objectively, not with some subjective evaluation of what the defendant's intent might have been, who knows what that was? The law only requires us to look at the objectively manifested intent of the parties, and the words or the text messages convey that pretty clearly. There was agreement between the parties at one point, extended over a number of text messages, confirmed multiple times over a period of days, that Jill was going to agree to deed a portion of a parcel to the plaintiffs for an agreed price of $3,000. Yes, there were discussions after that about other things, but there was never really any statement that $3,000 was not the price. And you to go beyond what the words say is just that. It's looking at the speculation rather than the real thing that was said by the parties. I think there's a strong case here.
Mr. Rick,
Yes.
let me interrupt you for a minute. So the statute of frauds certainly requires a writing for an enforceable agreement to convey real estate or convey an interest in real estate. And I think it says specifically a writing signed by the parties. We all acknowledge we don't have a writing signed by the parties. Is that correct?
There is no formal written agreement, Your Honor, but the statute of frauds does not require that exists. It only requires that there be a memorandum that conveys the terms of it. I've laid that out in the moving papers. I'm just looking for it here.
So what you're representing to the court is nowhere does the statute of frauds say there has to be a writing signed by the parties, only that there is a writing.
Yes, and here's the statute itself. It says every contract for the leasing for a longer period than 1 year or for the sale of any lands or any interest in lands shall be void unless the contract or some note or memorandum thereof be in writing and signed by the party by whom the lease or sale is to be made. Now, I guess the question is a text message a signing?
That's the very question I was asking, a writing signed, and I want you to address that because we don't really have anything signed. We do have text messages. We can verify the source of those text messages, but what happens to the signature requirement?
Well, and I don't know that there's an actual requirement that you see something that says Jill Bentley on there. I mean, these are clearly things that were written by Jill, affirming what she wanted to do. That's a sufficient signature in the sense that these are things she said she was going to do. So I can't cite you a case that says that, you don't need an actual signature of some kind, but I think to require that sort of eviscerates the statute. Because if you can have a memorandum that says what's going to happen and it's authored by the plaintiff, that should be sufficient as a signing. Certainly, it's a reduction to tangible form of what the plaintiff is saying, and that's a writing.
I'm not questioning the writing portion. I'm questioning the very language that you cite that says signed by the parties. Is there some case law out there that says, well, you don't really need to have it signed if it's an email or if it's a text message, as long as you can prove that it came from that person? And that's clearly not what the statute says. It says a writing signed based on what you just read to me.
Right. Well, Your Honor, I don't have a case that says that. There are plenty of cases out there that admit text messages, but I can't tell you that, there's a case out there that equates a text message with a signing. I'm saying that is, however, an appropriate reading of what the text message is. It's something authored by the plaintiff with her own fingers, saying what she's doing here. She's saying, okay, yes, that's super. All those words that indicate assent to this agreement.
I know that in the modern electronic age we live in, that there is such a thing that's recognized as an electronic signature, but in the process of doing that, at least in the more formalized settings, there's a process whereby you affix this electronic signature and simultaneously verify that you are affixing your electronic signature. I mean, I see all of those things, and I'm assuming they're being done to satisfy the statute of frauds. In your case, I don't see any of that. I mean, I don't think there's any dispute as to the parties had these exchanges, but clearly there isn't something signed. So I don't know if that's going to be a hindrance to me granting relief at this point. I can't just ignore that language without having some legal basis for ignoring that language. I realize your promissory estoppel theory doesn't require a signature. All it requires is a promise, an action taken in reliance on the promise. In this case, the action taken was the whole property was conveyed to Jill as a part of this settlement agreement, but only with the understanding that she was going to convey something back or something over to the other parties.
Yeah, I think that conclusion is inescapable. There's no way you can honestly read the text messages and conclude anything else. That there was the reason that the plaintiffs agreed to the settlement agreement was because everybody knew that there was a separate agreement by which Jill was going to convey the other smaller parcel. On the issue of signing, let me just reference the court again to my motion here where I say that there has been some case law on what constitutes a sufficient note or memorandum. And it notes that there are few, if any, specific and uniform requirements. This case just says some note or memorandum having substantial probative value in establishing the contract must exist. Its sufficiency in obtaining the purpose of the statute depends in each case upon the setting in which it's found. So I think the courts in general have some flexibility in evaluating whether or not that statute's complied with. Does the memorandum comply? I think the court should have some flexibility in that too, and not necessarily require an inked signature, something that says Jill Bentley.
Putting the signature component aside, there's certainly to have an enforceable contract to convey real estate, you got to have a price. Would you agree on that?
Yeah, yes, I do. There is some flexibility in statute of frauds on that, but yes.
Well, it can be a price as determined by a survey. I mean, there has to be a clear way of figuring out what the price is. The court can't just make up a price. There
Yes.
has to be a clear way of determining price. There also has to be a clear way of determining property. My understanding is at the time the written settlement agreement was entered into, we didn't have a legal description or even a something short of an actual legal description that says a half-acre parcel bounded by whatever. I know there's reference to a tennis court, and I guess that's pretty easy to figure out what the description of the tennis court is. But wasn't there some land in addition to the tennis court that was supposed to be part of this deal? How does the court determine the extent of the additional beyond the tennis court if the parties didn't specifically agree on that?
Well, I think they did agree, Your Honor. If you'll look at the text messages and the emails, there were text messages exchanged on the 9th, in which the $3,000 price was agreed upon. And then 4 days later, on the 13th, Jill, the defendant, authored an email to the trustee in which she described what area was to be carved out. She said that she wanted to have Mr. Bullen do something that was going to carve that out. I don't know why that didn't happen, but in any event, that didn't happen. But she did describe where she wanted things to go. I think that's.
It struck me as I was reading it that it was rather.
Lynn's affidavit.
All right, well, hold on. As I was reading it, my recollection is the description was rather vague. But let me find.
Yeah, it is Exhibit E to Lynn's affidavit in support of the motion. And right in the middle of the first page there's a paragraph where Lynn talks about the description of the tennis court area.
All right, let me find that. I got a lot of filings here to sift through. Was that separately filed or was it filed as an exhibit to a brief? I'm seeing an affidavit of Lynn Bentley that only has 2 paragraphs to it. I think that's the one you're objecting to.
Yeah, I'm not objecting to that one. This is one that was filed.
Oh, you're not
February
objecting. I'm sorry. That's one of the plaintiffs.
Yeah.
Forgive me. Jill. All right.
It would have attached to the original motion. Your Honor, I may have a couple times referred to Lynn meaning to say Jill, but you know who I'm talking about.
All right, I see that affidavit now. And which specific exhibit
It's
to that
Exhibit E.
affidavit?
Exhibit E.
All right, hold on, let me get there. All right, I'm looking at some email exchanges ending on January 13th. Is that right?
Well, this is an email that is from Jill Bentley to WT Care, which is Phil Willis's accounting company, trust administration company, dated January 13, 2019.
Nice.
Yeah, but that was a reply to an earlier email. I see the chain. I just was clarifying the last exchange in that was on January 13th. That's all I was trying to clarify. Because you can see it's a reply to one on January 3rd,
Right,
which itself was a reply to one on January 2nd.
correct,
It's the last email in the chain.
right.
All right. And this is all before the written settlement agreement was entered?
Correct. The settlement agreement was in February of 2019.
Okay. If I buy these parcels of land, I will owe my sisters 34.5. I will owe each of you 86.25. After we close with Mr. Bullen, I would like him to put in writing that Lynn and Gail will have the tennis courts and the extra parking lot and as much of the land directly to the south as far back as the apple orchard and the west just a bit short of my property. That sounds pretty vague to me, Mr. Rick.
Well, Your Honor, I have also attached as part of that affidavit a picture that is Exhibit G, which depicts the approximate location of the apple orchard and the parking lot. I don't think this is vague to the parties. It might be to you and me, but the parties knew what I was talking about.
So I'm looking at an aerial photograph. Is that what you're drawing my
Correct.
attention to?
Yes.
Exhibit G.
Right.
All right, let me get my bearings here. So parking area, is this a paved parking area or is it just a gravel, dirt?
No, there is a road that goes on the northeast corner of the property that starts to curve at the bottom there, where that road is. But the property line is just, there's no asphalt there. I believe it's just an area that the family used and what they called a parking area. I did ask one of my clients, I believe it was Lynn, to identify what those areas were, and this is her attempt to do that.
So is there just one tennis court?
There are actually two, one older, one newer. One runs east to west, one runs north to south.
Okay, I see two rectangular areas near what's described as the parking area. Those are the tennis courts?
Yes. The other thing I'll say on the issue of the description, Your Honor, is that, again, if you read the text messages, the parties clearly intended that there was going to be a survey. They had the general parameters of what this was going to be. They had it all in their mind what they expected it to be. And they all knew that they were going to have a survey done. That was discussed right from the very beginning, even before that written settlement agreement was signed. And we've submitted multiple communications that confirm that the survey was intended by both parties. And I cite one authority to the court there in a similar case where the legal description wasn't precisely defined, but the parties had a way to determine it, and that was enough for that court.
Well, this didn't all fall apart over disagreement as to where the survey line, it fell apart over the price. Is that fair assessment?
Well, I guess that depends on who you talk to. I think the defendants may have a different opinion on that, but I think you're correct.
They're the plaintiffs.
Okay.
Well,
So the area that's highlighted in blue on this exhibit G, is this the entire nearly 11-acre parcel that the tennis courts and parking area were to be carved from?
Yes, that's correct, Your Honor. I would note that since that blue line depiction, Jill has carved out a square in the upper left-hand corner, which is where her residence is located, and that is a separate parcel currently. But yes, at the time of the conveyance that's involved in this blue line depicts the original tennis court parcel.
And ultimately, the problem, well, let me ask Mr. Kendall.
Finally,
Is the issue that the primary issue your client has is what is to be the price for the carve out versus what exactly are the parameters of the carve out?
actually, Your Honor, we have issues with both sides, both elements of the contract. The problem that we have with the parcel, the referral all along has been just the tennis courts. And Jill Bentley understood the tennis court property to consist of approximately 0.86 acres. They can all, they can define it the way they want to, but ultimately they have to reach an agreement as to what the parcel looks like, what the confines of it are, how big it is. And what happened was the plaintiffs engaged a surveyor, and they instructed the surveyor as to where they wanted the lines drawn. And they enlarged the parcel from 0.86 acres to 1.4 acres. And the defendant never agreed to that. There's nothing in writing. There's nothing that suggests that the survey that's been proffered was acceptable to her or that she ever agreed to it.
Well, let me ask you, as to the 0.86, that sounds like a pretty specific parcel of land. Is there, how is this 0.86 defined or described?
It was, originally came about because they were using the tax roll maps to show the parcel that Jill was buying, in effect through the distribution from their parents' estate. And the property was divided up into roughly 9.96 acres of pasture land. And the entire parcel was 10.82. And the pasture land was 9.96. And the remaining property was what was devoted to the tennis courts. And that's how that designation came about.
Correct.
That was the work
So there's an actual tax description out there for the parcel that's occupied by the tennis courts?
No, it's part of the tax. They were working off of a tax roll map, and I believe it is part of Mr. Jora's appraisal. And it was a parcel. The parcel was 10.82 acres. Just as a note, the parcel that was in the survey that has been submitted to you is larger. It is actually 11.49 acres. And the defendant believes that the only way they can go from 10.82 to 11.49 is to take some of her property. that she already owned that's contiguous to this property.
Your Honor, I'd like to address this issue of the 0.86 when you think it's appropriate for me to, because I believe Mr. Kendall's absolutely incorrect on this.
All right, I'll give you a chance.
You want me to do that now or wait for Mr. Kendall to continue?
I thought
If
you
he
were
doesn't
asking
mind-
to interrupt me.
If he doesn't mind the interruption, that's fine. I can hear that now.
Okay, well, the 0.86 is an absolutely manufactured number. Where the numbers came from, if you look at the appraisal, was that the appraiser selected a hypothetical 0.54 acres of land, not anywhere geographically located in the larger parcel, but just to have a hypothetical parcel to compare with comparable sales, which were smaller in size. And so he picked 0.54 acres, which was exactly twice the size of one of the parcels he was comparing with for a previous sale, and evaluated the price of the land based on a 0.54 acre parcel. He then said that the 10.5 acres, which he believed he was appraising, if you look at the appraisal carefully, he was using 10.5 acres, subtracted the 0.54 acres and came to 9.96 acres excess. So he's appraising a 0.54 acre parcel and 9.96 excess acres. Where Jill arrived at the 0.86 is to subtract 10.82 acres, referenced in the appraisal in a few places, as one of the sizes of the parcel because the appraiser wasn't sure what the size was. He subtracted 9.96 acres, the excess acres from 10.82. That gives you 0.86. That's the only way you can arrive at 0.86. It's nowhere referenced in the appraisal. There's no tax parcel ID for that. That's strictly a calculated number that Jill has come up with, or that Mr. Kendall has come up with. I think it was Jill. I'm not saying that she's dumb or anything. I'm just saying that's incorrect. That's not what the appraisal says.
Well, let's put it this way, Your Honor. The defendant believed that she was committing to sell a parcel of property 0.86 acres in size. That's pretty simple.
I doubt that at the time of this original agreement, that's what she thought it was, Your Honor.
Well, regardless of what anybody thought it was, for me to engage in some specific performance order, it doesn't matter what anybody thought it was. What matters is, what did they express? And if they didn't express it clearly, and they and agreed upon it, and didn't express it in a way that makes it possible to calculate with some precision what the acreage is, how in the world do I specifically enforce that?
Well, Your Honor, that was the whole reason for the survey. You know, they had some outline generally of what they believed was going to be conveyed, starting at the northern border, going down to the apple orchard, going over to almost Lynn's property, over the road. That was the general area they were going to convey. And they wanted to commission a surveyor to more specifically define that, which they did. It wasn't just my clients who did that. They talked about Jill getting a survey right from the very beginning. The parties knew there was going to be a survey.
Who initiated the survey?
So the survey was done by Elise Fish's husband, Brian, who Elise is one of the sisters in this. I don't know. It may have been the plaintiffs who actually contacted Brian to do that. As I recall, they talked to Brian. He was talking about having someone else from another company do it. He ended up doing it himself. I mean, it wasn't like the plaintiffs were going behind Jill's back to do a survey. They just thought, well, Brian is going to do it. He has a survey company. Let's have him do it. And Jill knew about that. Jill agreed to pay. And there's text messages to confirm that.
But hold on.
Okay.
So, somebody had to tell the surveyor what to survey. Here's where we want you to put the line. That had to be communicated.
Yes, and I think that was probably the plaintiffs, although we've got text messages that show that by the end of the survey, Jill walked the property with Brian and agreed to the parameters.
Well, that's not exactly true.
We've got a text message that says that.
So she walked the property, she said that she agreed to a parcel of property which appeared to be approximately 0.86 acres. Your Honor, and can I just add one more thing on this issue, and then I would like to go have a chance to talk about the price issue.
Sure.
The plaintiffs responded to discovery request and gave me another 100 pages or so of text messages. And these text messages were, or included amongst these text messages were the messages from the plaintiffs to Mr. Fish, and they pertain to the survey. And it was the plaintiffs who were explaining to Mr. Fish what they wanted. They did some mock-ups. They came up with one parcel that was 1.13 acres. And then the plaintiff, Gail Bentley, sent a text to Mr. Fish and said, I would like it to go back further towards Jill's pastures to include Mom's old shed, if we can, since she took so much of our property away. And then the surveyor replied, okay, I'll locate the sheds when I go back out. I'll adjust the lines and see how much acreage it will be. Then we can make sure that Jill agrees and the township approves. So there was no agreement. The plaintiffs were just defining what they thought they wanted to take.
That's really not consistent with the email message that she sent to Willis Trust Care. You know, there was a general area. Your Honor, the text message I'm referring to from Jill Bentley is attached to our final reply here, attached to Lynn Bentley's affidavit. And here's what it says from Jill Bentley. Hey, everybody, I did a walk around with Brian the other day of the property. I think we have the line set. I think it will be about 1.6 acres of land, FYI.
And Ms. Bentley has told me that she did, and this is a consistent thing. This was in her deposition, it's in her affidavit. When she does text messages, she does talk to text. Are you familiar with that, Your Honor? That's where instead of typing, you just talk to your phone and hope that it translates what you say. She believes.
I'm very familiar with it.
Okay, she said to the phone, talked to her phone, said 0.86, and it came out 1.6. And 1.6 is not the survey. It has no reference point. So here's the thing, it's a muddle. How can you make sense out of this that say that there are not facts and issue that had to be resolved by a trial?
Well, even beyond that, even if I were sitting here at a trial today and have heard all this testimony, I'm not sure if I would be in a position to rule definitively, okay, this is what the parties agreed is the size of the parcel. This is what the parties agreed was the price. I'm looking ahead, and this is going to be a bench trial, not a jury trial. It's not a question of taking something away from the jury. I'm just looking ahead. What am I going to do with this? So let's talk about the price issue, Mr. Kendall.
In January of 2019, one of the Elise threw out this number of 3,000 to 5,000, and they talked about that. Jill testified at deposition that she believed that her sisters had read the appraisal and that was what the number was. Well, as it turns out, they hadn't read the appraisal. Jill hadn't read the appraisal, and that was not what the property is worth. But they didn't stop there. They continued to communicate with each other by way of texts, by way of emails, and ultimately they settled on the appraised value as being the transfer price. And it wasn't just a matter of a few texts. That ended up being part of the settlement agreement where they specifically agreed that the Mr. Jora's appraisals for all of the properties would be the basis for the distribution of their properties and the basis for any future transactions regarding the property.
It says that in the settlement agreement, or it says it in communications around the time of the settlement
It
agreement?
says that in the settlement agreement.
Let me put my finger on that. All right, I have it in front of me, I think. Hold on. Jack P. Bentley and Mary Ann Bentley Trust Settlement Agreement. That's the settlement agreement, correct?
Correct.
All right, and where do I see where is the reference for the appraisals?
Page 3, paragraph 12.
All right. I just looked at the next recital. All sisters have received and studied the 5 Jors appraisals since shortly after their issuance. Are you telling me that that's not true? They hadn't?
I couldn't tell you exactly when the plaintiffs read the appraisals.
Had your client read the appraisals at this point?
No, I don't believe she had.
I don't think any of them had, Your Honor. They all knew what the price was, the appraised price of 125. I don't think any of them had really, they may have seen the appraisal, they certainly didn't study it.
Well, it sure, I mean, Mr. Rick, how do you address this paragraph 12 that says that the Jors appraisals shall be used?
Well, what they're being used for, Your Honor, is to set the value of the land that was being transmitted from the trust to the beneficiaries. And there's not a dispute about that. You know, yes, the price of the tax court parcel was the appraised price was $125,000. My clients don't contest that this was the agreement with respect to distribution of assets from their parents' trust. They say there was a whole different agreement, and that this agreement was only entered into only with the understanding that there was a separate agreement by which another sale would happen. They don't dispute that these numbers were correct for the distribution of the parents' properties.
So when it says sisters have agreed in principle and shall confirm that hereinafter the Jors appraisals set forth on the distribution schedule shall be used as the value of the respective parcels, that they weren't talking about the carve-outs, the tennis court, the parking area, and whatever else was supposed to go along with it, that this reference to the respective parcels is to something else?
Well, yes, and those parcels are described in an attachment to that settlement agreement. If you look at the very last page of that, it lays out what the various parcels were: home, pasture, barns, tennis court, woods, crestwood. Those were all existing tax parcels. The tennis court was the $125,000 parcel that went to Jill, out of which was to be carved the smaller tennis court parcel.
While we're on the settlement agreement and you've got it in front of you, Your Honor, can I point out to that, or could you read paragraph 10 of the agreement?
I've read paragraph 10.
So here's where we're at in the chronology of this case. They've had some conversations about a specific price. Those conversations have moved on and they're talking about the appraised value. I attached emails from the plaintiffs to Jill acknowledging that the appraised value was the value that they were talking about, that they were contemplating. They signed the settlement agreement. They agreed that the appraisals, the George appraisals are the basis for the distribution of the properties. They do that in February. In April, Mr. Rick sends a letter to the defendant. And in his letter, he says, the purchase price was to be based on the appraisal. And then he goes on to show their calculation of how they determine what the tennis court parcel is relative to the total parcel. And then the plaintiffs filed suit with your court. In their first complaint, they alleged that the agreement was based on the appraised price. Now they file an amended complaint, completely abandon the idea that it was based on the appraisal and try and go back in time to an agreement that they say predates the agreement relative to the appraisal and their first complaint. I think just simple contract law tells us that the last contract, the last agreement is the final agreement. And that's where it broke down, figuring out what did the appraised price mean.
Governor, let me just address that point if I can quickly.
Go ahead.
You know, I think I can tell you the history on that. You know, when I was first contacted by the plaintiffs in the midst of early development of the pandemic, working from my basement, you know, we did file an original complaint, which was based upon what the parties remembered at the time. But this is sort of the beauty of the statute of frauds. The statute of frauds requires that there be a writing. And so as I further communicated with the plaintiffs, they found and recalled text messages that are now what form the basis of the amended complaint. And so, you know, we initially filed based on what they were remembering at the time, but the statute of frauds is designed to avoid problems with memory and require a writing. And that's why we produced that. That's why we amended the complaint. There's a writing which explains what the agreement was.
Can I point out the simple, unavoidable fact that the statute of frauds requires a writing signed by the party to be charged? And this is exactly why the statute says that. So that we don't end up in these muddles of what was said, when, where, and whether or not it pertained to any of the critical elements of a contract. If a written agreement had been developed, which the plaintiffs suggested at several occasions, which would suggest that they did not think that they had an agreement, then everybody would be able to focus in on exactly what they were talking about. What was the price? What was going to be sold? And they would agree upon it and it would be done. That's why the statute of frauds exists.
Well, it was actually Jill who first suggested a writing. She said that early on. She said, I'll put it in a writing so you don't have to worry. It wasn't just my client's idea.
All right. Well, I am not in a position to make a ruling as a matter of law that there's no genuine issue of material fact here. I believe it's sufficiently muddled that I couldn't possibly decide it as a dispositive motion. I think I'm going to have to hear testimony, judge credibility, decide which of these writings, if any, were part of the agreement. I think it's going to require a trial, gentlemen. I guess what I'd like to inquire into before then, has there been any attempt to resolve this? I know in the early communications among the sisters, there seemed to be a real spirit of teamwork. Let's get this done. We're all on the same page. We're getting along. This is great. And then now we're at this point where they're at loggerheads. You can spend a lot more money on legal fees, or you can, regardless of what the original deal may have been in one person's mind versus another, come up with a fair resolution. Has any effort been made to trying to achieve that?
There have been no offers of settlement made, Your Honor.
We've had some talks along the way, but we haven't actually had any serious numbers exchanged, or we've talked about
All
mediating.
right, well, here's what I'm going to do. I am denying the motion for summary disposition. I am ordering the parties to participate in facilitative mediation by a facilitator of your choice. I want that done before any more legal work is expended on this file.
Is the trial date, I'm sorry, I didn't mean to interrupt.
I'm going to extend the trial date until you've had a full opportunity to discuss resolution with a facilitator. The parties are to share the cost of that facilitator. It will be one of your choosing. I'm sure you can at least agree on who could do that. And as soon as you can agree on someone, schedule a date the earliest possible on his or her calendar to get this process rolling.
Will that be
when you?
I'm sorry
Go ahead.
again, Your Honor. I was just going to say, are you ordering an in-person mediation?
I don't see any reason why we couldn't. You're either vaccinated or you wear a mask.
Yep.
Well, where does everybody live?
My clients live in Colorado and Tennessee.
They're usually more productive when everybody's present. I'm assuming with property still in the area, there are times when they visit that property. Is that a fair assumption?
Yes.
I think it needs to be in person. It's far more effective that way. You know, I'm willing to give some flexibility so you can schedule at a time when you would otherwise could be in the area, enjoy some time here. I'm sure you've got some good memories floating around this whole area, and it's you're probably anxious to see what the beach bar looks like now that they've renovated it. I'm kind of disappointed in the renovation myself. We just ate there last weekend, but it was still fun. So I'm willing to give you time to get that facilitation scheduled. I'm not going to give you a deadline, but just as soon as possible date that you can get your agreed upon facilitator to schedule something that works with everyone's schedule. And let's try to get this resolved. I think you're far better off getting it resolved. And I think for that to work, everybody's got to be somewhat flexible and try to come up with something that you can all live with. That's my, and hopefully put the litigation to an end and try to make some peace.
Your Honor, would you like me to draft that order?
Please.
Okay.
And we'll reschedule. I don't know what your trial date is currently, but we'll reschedule something no sooner than 30 days after facilitation is completed. I won't have any trouble getting you a spot on my calendar for a bench trial.
Very well. Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Good luck, everyone. Okay, this is a matter of Berg versus Berg. Counsel, state your appearances, please.
May it please the court, Ryan Phillips, 73731, on behalf of plaintiff, Carrington Berg.
Good afternoon, Your Honor. Tara Pearson on behalf of the defendants, and with me is Jennifer Berg. Hello.
Okay, and we are here, I believe, on somebody's dispositive motion, sorry. When last you were in front of me, I think I strongly encouraged there be some discussion to try to resolve this. Clearly, there's a mortgage. Clearly, it's in default. Clearly, there's an amount owed that should be paid. I mean, am I right so far on all of that?
Yes, sir.
What isn't, what, at least what wasn't agreed upon when you were last in front of me, I think was, well, how much is owed on the mortgage? And I think that's where we left it. Has there been any communication on an agreed upon foreclosure amount?
There has
Yes.
been communication. There is not an agreed amount.
Without telling me where you're both at, how far apart are you?
I can tell you it's actually one issue. It is the issue of the funds my clients expended to protect the property from waste and procure insurance.
What is that amount that you're claiming for that purpose?
The expenses with interest amount to basically $39,000.
And Mr. Phillips, your client's position that not all of that was necessary to prevent waste.
Correct.
I saw pictures. Looks like the place was
A disaster?
essentially gutted and being rebuilt.
No, Your Honor, there was a small building there that was torn down, and this was a new construction that was just never, no task was ever completed within the,
And who was in the process of rebuilding the structure? Was that the decedent?
the decedent, Your Honor. He's the one that tore down the first building, and he was the one that was doing the work himself for this new structure.
All right, and all of those improvements were at his expense.
Well, so the funds that my client expended, Your Honor, were a result of the condition of the property at the time of the decedent's death. At the time of death, the house was completely absent of any doors and windows. My clients learned that there was no insurance and there were issues with citations and blight with the township. So what my clients did, Your Honor, was they took the steps necessary to both satisfy the township and obtain insurance. And that was stuff that was done to the exterior of the home. The interior is in the same condition as it was at the time of death.
All right, so regardless of whether everything they did was necessary to avoid waste, is there any question that what they did added value to the property, Mr. Phillips?
No.
So,
May I be heard more fully?
sure, of course.
Okay. So it's, well, if you want to ask more questions, please do so. I just want to have an opportunity to speak at length on what I think the issue is.
Oh, okay. I thought you wanted to be heard immediately.
Well, the simple answer to your question is no. There is no disagreement that the work put in by our defendants added value to the property. And it's definitely not my client's intention to try and stiff them on that. It is the case that I believe the best way to handle that money that was invested into the home is as a claim in the decedent's estate. Because the mortgage itself in the four corners is the only remedy that the parties agreed to, was that the defendants would have the right to foreclose on the mortgage. And because parties have a right to provide for their own remedies and decide what it's going to be, the option to simply put money into the property was not an option that the defendants had.
So your position is they certainly should have a remedy for the value that they added. It just shouldn't be the foreclosure process.
Correct.
So the value that's being claimed, the 39,000, is it disputed that what they did in fact added $39,000 value to the property?
The actual amount that they put into the property was about $20,000. What they're asking for is 10% interest on that money.
Is interest, that's the interest rate provided in the mortgage and note?
It's the interest rate provided in the mortgage that deals with procuring insurance and payment of taxes. It doesn't deal with fixing the property.
Is that a default rate?
The mortgage states if said mortgager makes default in the payment of any junior or senior liens on the premises, any of the aforesaid taxes or assessments, or in procuring and maintaining insurance as above covered, said mortgagee may pay such taxes and affect such insurance, and the sum so paid shall be a further lien on said premises under this mortgage, payable forthwith at the interest rate of 10% per annum. So,
Okay.
opposing counsel, you say that they needed to put money into the property such that they could put insurance on it. But I don't believe the mortgage calls for that, allows for that. If there is default, the mortgage says simply in the 8th covenant that the mortgagees have the right to foreclose on the mortgage.
So I'm looking at the photographs that are attached to the affidavit of Chris Ball. Those photographs are all of the condition of the property at or around or shortly after the death of Gary Berg.
Yes, Your Honor. There were, it is my understanding that there was some more stuff in the home at that time, but there's since death, yes.
All right, I was more interested in the state of construction than I was in, you know, items that were being stored there.
Yes, that is the interior condition of the property at the time of death. Except, Your Honor, at the time of death, there were no doors or windows or anything covering any. Your Honor, at the time of death, there were no doors or windows or anything covering any of the holes. So the pictures that you see have some windows, they have some tarps. Those were not there. It was a shell. They were all open.
All right, has there been additional work done beyond what's disclosed in these photographs?
No, Your Honor. The only work done was to the outside. There was windows, doors. There was no roof, so a roof had to be put on. And the siding was completed, and then the township required a deck with rails and a porch with rails. And no work has been done since that time, Your Honor. So honestly,
Was everything that was done required by the local authorities?
it was required by the township and to obtain insurance, because they had to comply with both. They had to comply with the township, but they also had to procure insurance because the decedent, they discovered, had never obtained insurance. And in its condition, it was not insurable.
When were all these maintenance expenses expended or incurred?
I want to say 2013. Hold on, let me look at my notes here, Your Honor. If you'll give me.
So is this home essentially in the same state today
Yes, sir, it is.
as described in these photographs?
Yes, yeah, actually, Your Honor, those photographs were taken a few weeks ago. The maintenance, Your Honor, to answer your question, this stuff was done in 2011 and 2012. Your Honor, as soon as the township was satisfied and the insurance company was satisfied, nothing else was done to the property other than the grass being mowed, because that's also a township issue and the neighbors would make complaints, which they're doing now.
Yep.
Because plaintiff is not maintaining the property.
All right, and let's see, let me find the mortgage. Where would I find the mortgage itself? Okay, I see it, never mind. It's Exhibit 1 to the plaintiff's motion for partial summary disposition.
And Your Honor, on page 2, under fourth, under the default paragraph, the mortgagee may pay liens or taxes, effect such insurance, and the sums paid are a lien with 10%. Your Honor, that's why they did this. This is not a vacation home, clearly. And they weren't fixing this up to stay there.
No bathroom.
There's no water. Mhm. And frankly, Your Honor, it's disingenuous for them to say that this should be a claim of the estate. The only asset of the estate is this house and any potential funds that they would receive above and beyond the foreclosure. And when it comes to estates, Your Honor, I do plenty of those. I know exactly what's going to happen. If there's any overage, it's going to be expensed out through administrative expenses and anything else. So to say that the claim can proceed through the estate is completely disingenuous. There will be no assets in the estate.
Yeah, pardon me, I'm just reading the mortgage.
Certainly. I'm sorry to interrupt you, Your Honor, but I think we've lost Mr. Phillips.
I see that now. Mr. Phillips, do we have an audio connection?
Yes, I apologize.
So clearly this mortgage requires the mortgagor to keep the improvements in good order and repair, promptly pay for all repairs and improvements, and to commit or suffer no waste of the premises, and to permit or suffer no unlawful use thereof. Based on what's been represented to me today, the only expenditures that the defendants made was to protect the property from waste. It clearly was in a condition where they needed to step in and do something, or their security was subject to being lost. Your contention is though the only thing that allows them to collect 10% default interest is failure to pay liens or taxes or insurance. And those are the only things they can get the 10% default rate on. Is that your position?
Yes.
So you don't question the value of the improvements that they made to secure the property. You question the default interest rate that should be assessed, if any, on those expenditures.
My first position is that the remedy that the parties selected is the foreclosure of the mortgage. That's the only thing that the parties agreed to. It's the only thing that's in the four corners of the document. The brief that I submitted establishes clearly that parties have a right to select their own remedy, and parties aren't at liberty to select remedies that they would rather have rather than those that were agreed to. I'm not disputing that the money spent on the property added value to the property, and I'm not trying, nor is my client, to be clear, to fail to compensate the defendants for the money they put into the property. But if I were to, and I hope this doesn't happen, if I were to die this afternoon, I know that Chase Mortgage would not likely come and repair my property. They would foreclose, because that is the agreement that we have, same as the mortgage here. What the defendant should have done if they felt insecure was that they should have foreclosed. They didn't, which got us into this situation. If you were to rule is not going to be a part of the mortgage, a claim would be allowed by the estate. And if you are to rule that money is permissible under the mortgage, I don't believe it should earn 10% interest, because the amount that they're asking for is $20,000, and the interest on that $20,000 is another $18,000, which makes it very difficult for my client to sell the property, and it's not an expense that is, or it's not an interest rate that is anticipated in the mortgage itself.
It certainly appears to me that the defendants are entitled to foreclose on this mortgage. They are entitled to the $50,000 that was the agreed upon amount of the mortgage. Well, there's a reference to the mortgage note. What does it provide as to what the payments were supposed to be? Does anybody have the mortgage note?
I've never seen a mortgage note.
Your Honor, I attempted to get the mortgage note from Mr. Flack's office, and they would not respond. Mr. Flack is the one that prepared these documents all those years ago. I don't have a copy of the note. When I saw that provision, I also tried to find it, and I was not provided with that.
All right, absent that note, I couldn't order any interest on the $50,000.
Correct.
And I don't know if you're seeking that, but clearly the defendants are entitled to interest at 10%, and nothing unlawful about that, for taxes or other assessments, for junior or senior liens. I don't think there were any of those. And for procuring and maintaining insurance, without a doubt. With respect to the improvements, I understand that these are certainly, as a matter of equity, something that the defendants should be able to recover. But I do agree with Mr. Phillips. Having expended those things, they are not covered by the default rate of interest. So what that leaves the court with is, since I don't have a note that talks about any of that thing, anything in that respect, I think as a matter of equity, a reasonable rate of interest on those improvements, and I would say that the rate of interest would be consistent with the rate that applies to money judgments in the state of Michigan. And I would allow the foreclosure to go forward on that basis if the interest is recalculated in accordance with the judgment rate as to those extra funds that were expended. I don't think the mortgage allows a default rate to be applied for those things. If you would recalculate the amount that's owed in interest on those amounts, I would allow the foreclosure to go forward on that basis.
Thank you, Your Honor. I will do that.
May I be heard?
Yes.
Ms. Pearson, I think if you'll give me an opportunity to speak with the client after this hearing, I'm willing to bet that we'll stipulate to that. It would make entry of the order easier and certainly make it easier for you to get the property on the, I don't know, is it a docket? I know they've got the public auctions every Wednesday, but I don't know what they call it. But you probably want this on for next Wednesday.
Yeah, I don't know what they call that either.
But they do really do it.
Yes, that is correct. I mean, they know that I'm doing this on a weekly basis, so they are for, yeah, I do want to get this done as soon as possible because obviously that helps both of us.
I know that my client is on the call here. I haven't seen her face, so she may be audio only. If you allow me to call her, I can, and if you're going to be in the office for a little bit yet this afternoon, I'll give you a call.
Yes, I will be.
All right, I'll look for that. If you have difficulty and you need to get back in front of me, just get a hold of my law clerk.
Yes, thank
We'll
you,
get you.
Your Honor.
Gotcha.
But I would expect this should be something that's pretty easily calculated.
Yes.
And I think the defendants are certainly entitled to move forward. They've been waiting for a long time. They shouldn't have to wait any longer.
Thank you, Your Honor, for your time. We will work to get that.
You're
order.
welcome.
Thank you, Judge.
Have a good day.
Have a good afternoon.